Democrat operatives are now trying to remove other candidates from other ballots in important states. You remember this guy, Mark Elias. He was very prevalent in 2020. He runs the Elias Law Group, and he was on the outs a little bit with the DNC and the Biden administration, but he's back in the picture now with this new letter to a swing state warning them to take this candidate off the ballot or else. The candidate, as you can see, is Cornel West. They've already succeeded in rigging the ballots against RFK and against Trump now. We saw that in Michigan, the Supreme Court of Michigan, a Democratic Supreme Court, came back out and actually added RFK Jr. back to the list after the deadline has been passed, even though it's less accurate, right? So they're going to actually disenfranchise their own voters by having them vote for somebody who's not running. It's incredible. They're only doing that because they want to subtract votes from Trump. They want to leave a protest vote in there to siphon votes away from him because they're cheaters. Now, as we saw, Jocelyn Benson used obscure rules, and the Supreme Court basically made it up there and said, oh, it's allowed. There's no basis for you to demand that you get off. And so they inverted the standard and they kept RFK Jr. on the ballot, even though he's not running there. And the decision had already been made. The deadline had already been passed. In fact, the confirmation from Jocelyn Benson had already gone out to take him off. So they're going to put him back on to make a less accurate ballot because that's how big of cheaters they are. But they're trying it again. So Mark Elias is doing the same thing. You can see the Daily Caller got the exclusive on this, and it's a letter that went over to Virginia. You can see that is in this letter from the Elias Law Group. It's being sent via email to Chairman John O'Brien for Virginia's State Board of Elections. So it's a nasty gram saying, you better do something about this Cornel West fella. He shouldn't be on the ballot, and we need him to be removed because he might siphon votes off from Trump. So from Biden, from Harris. So you see, this is a situation where if it helps them, they will keep a candidate who's not running on the ballot. And if it hurts them, they will try to remove a candidate who is running from the ballot. The Democrats are cheaters. This is how they win. They've got no ideas. They're just bullies. So you can see this letter came out, and it's going over to the Board of Elections in Virginia. And they say, hey, dear members, we write on behalf of Clear Choice Action. Yeah, regarding the Department of Elections and the Board of Elections and your last minute decision to qualify Dr. Cornel West. He's on the ballot now. He's going to be on there in Virginia in November, saying you guys violated the law when you qualified Dr. West, and you must reverse your decision immediately. Take him off the ballot or else you're in trouble. Virginia law requires that each nominated elector pursuant to this article shall cast their votes, and they shall subscribe to an oath, which shall be notarized that he's in fact a citizen and legal resident of the Commonwealth. They say, see, he shall take an oath that's notarized. Now, all but one of Dr. West's electors failed to comply with this statutory requirement. And so you must submit these elector oaths. So in other words, he didn't fill out the paperwork right. Okay. So you didn't fill out the paperwork. You got to put this oath. It's got to be notarized. And your electors didn't do that. So these lawyers are looking at the paperwork. On August 27th, the department did what the statute mandates. It disqualified West from the ballot because he didn't do this. But then the department's letter was not a discretionary act. While the statute allows the department to also be furnished with other evidence, it does not authorize them to waive the oath. And so they violated the law. So accordingly, you made a mistake when you reversed your original decision to disqualify him. So you disqualified him. Then in the qualification letter, right? So they say, nope, you don't, your paperwork's bad. Sorry, you're disqualified. Then he probably submits some new paperwork and you say, oh, okay, now you fixed it. In its qualification letter, right? So once he fixed his paperwork, the department claims without further elaboration that, quote, they say that we're now satisfied that each of West's electors have affirmed their citizenship. This is crazy. So suddenly the Democrats care about citizenship? This is a new thing? Hold on a minute. Your electors might not be citizens of the United States. This is what they're upset about. We can't even prove they're citizens. Where's their ID? They didn't take an oath and it's not notarized. So we can't confirm that they're citizens. And so it's a citizenship problem. It's a citizenship paperwork problem. The Democrats want these guys to be citizens, but not the people who are voting for them to be citizens. This is really weird. Almost like it doesn't matter what the perspective is. They just don't want people who threaten their power on the ballot because they have no values at all. But the legislature determined the department does not have the authority to do that, though. You can't say that they're satisfied. The legislature determined that elector oaths were a legal precondition, and you must do those. So you must take an oath. As noted above, the Virginia law allows the department to, quote, also be furnished, be furnished if it requests with other evidence that they're qualified. But such satisfactory evidence must be in addition to the oath. So you see. So just think about this differently, right? Like this is Jocelyn Benson trying to get one of their candidates on the ballot. They would say, oh, no, it's totally fine. The law says you can also give other evidence, right? Like you don't need to take an oath, but you can also be furnished with other evidence. They say, no, you can't read it that way. It's not either or, it's oath plus. But that doesn't really make sense because they're saying also, right? Also be furnished. They're saying it's subsequent to. But you might say also, if that doesn't work, if you can't take an oath, just give us this other stuff. And so you're mixing those words. Is it also as subsequent? If you take the oath, the problem with this logic is if you take the oath, why do you also need other evidence? The oath is, you're done. Take the oath, you're done. So you don't also need more evidence. So it's either take the oath or give us other evidence, I think. Now they say, moreover, the petition may also fail for another reason. One of his electors, Ben Black, don't know what his ethnicity is, submitted an elector oath containing a notarization date that differs from the date of the elector oath signature. So the notary date is not the same as the signature date. So his elector has to go too. The elector oath is invalid because it wasn't signed in the presence of a notary. Absent evidence to the contrary, it cannot be considered notarized. So another technicality. And so given that localities are scheduled to begin printing ballots and the September 20th deadline for printing absentee ballots is fast approaching, you must take immediate action. Get rid of Dr. West because he didn't take the oaths. And you must instruct all local election officials to ensure that Dr. Cornell West's name is not on the ballots. If the department refuses to take these actions, we're going to sue you. We're going to seek litigation, including an injunction and a writ of mandamus to make sure that we throw him off the ballot. And they give us some background here, right? So they say, okay, look, it's HB1. To qualify for this, you must submit your elector oath forms by noon. And he hasn't done that. Each elector oath is required to be notarized, and you got to sign it in the presence of them so they know it's you signing it. In other words, you must be signed in the presence of the notary. So one of his electors was bad, according to them. Now, the department disqualified him appropriately, and then they changed their mind. All right, so let's see. Did he rectify his paperwork? On August 7th, the department correctly determined that he failed to qualify for candidacy because all but one failed to sign the oath. The department specifically found that 12 of his electors submitted previous versions that were no longer valid. Okay, bad paperwork. 10 days after the department disqualified him, his counsel then asked the department to reconsider, referencing the Purcell principle and arguing that because his oaths were executed prior to that date on July 1st, statutory amendment, they should be accepted, right? So that, in other words, the law changed after, and so they should be able to relate it back to the original oaths. Now, Dr. West's counsel also stated that the notarization date on the election oath is a scrivener's error, okay? So they were there together, but the person who just signed the date was wrong. They were there together. It's just a mistake. It's a typo. Now, in response, the department reversed. The department said, okay, so that makes sense. Yeah, it does relate back. We will say, it's like if you do something and then the law changes, you still get credit for doing that thing. They're like, okay, moving forward, yes, we'll get a new one, but we already did this. The deadlines are, so we just count that. And they said, yeah, that makes sense. So they counted it. And the other one is not a problem either. So they rectified. In other words, there was no paperwork problem. So the department reversed and they decided on September 6th, the same day, to qualify him for the ballot. Now, the department indicated that it is satisfied that they affirm their citizenship, that each is a registered voter of Virginia, and thus each is eligible to serve as an elector. And they say, sorry, no, not sufficient. You have to take a specific oath. All candidates must take the oath, and it must be a new oath. Because they passed this law, there's an effective date of July 1. And they said, we signed it all before July 1. And so that is, we can relate back to before that date. The law just went into effect. So let's count those. They said, yeah, that makes sense. Now, as the department recognized when they originally disqualified him, others signed the previous version of the oath. And he did not seek to qualify as a candidate until after July 1st. And so they should have executed their oaths after the date, is what they're saying. Now, he said he wasn't aware of the new forms, but regardless, it's their responsibility to do this. If he's confused, his counsel should have told him about it. Now, to the extent that he defends his noncompliance by blaming the department, that's not sufficient enough. And it is not the General Assembly. It's not like they acted in secret. They did this all publicly. So you cannot excuse his failure. And you cannot say that it's also furnished by something else. Like he needed to take the oath specifically. While Virginia law does allow the department to also be furnished, if it requests, with satisfactory evidence that they are valid, it cannot replace the oath, right? So there's a good argument that they are in compliance with the law. They're making the argument that they're not in compliance with the law, but there's a literal subsection of the law that says, yeah, you can also give us other satisfactory evidence. And this doesn't make sense if this is necessary. This is meaningless. If they take the oath, what do you need the other evidence for? So it reads to me more as an either or, not an addition. The department does not have the authority to disregard legal requirements. They're not. They're exercising this one. They've gotten other evidence that they're valid. And the notary had a good explanation. Notaries make mistakes all the time. Now, it appears that they did not sign elector oaths in the presence of a notary as well, right? So the notary is just not sufficient. That's what the Democrats do. The petition also includes 2 elector oaths containing a different notarization date. This person signed their oath on that day. This one's another date. This one's on this date. This one's another date. So a scrivener's error doesn't matter. The date of notarization is important. If that's a mistake, the whole thing's a mistake. So get it done again. And he didn't get it done again. So throw him off. And finally, the Purcell principle doesn't apply. It's derived from the Supreme Court case. Purcell stands for the principles that federal courts should not stop a state election law in a period close to an election, right? Let's have an election. But they say it doesn't apply to states. It is only for federal courts. The Supreme Court has said it is one thing for a state on its own to toy with election laws. If states want to meddle in their elections, they can, but the feds won't do it. So you can meddle in this and throw him off the ballot. Don't let people vote for him because he might take votes away from Kamala. The Purcell principle doesn't even apply here, and for the reasons set forth, we urge the department to disqualify Dr. West from the ballot and instruct all localities to print ballots without his name. Signed by these 2 attorneys, Jonathan Burkon and Aria C. Branch, counsel to Clear Choice Action, as they continue to try to, in my opinion, rig the 2024 election by throwing this candidate off the ballot for technicalities. There's a good basis for him to be on it, and the board acted appropriately under the provisions of the law. But they don't want him on there because he might take away votes from their fake candidate. And the lawfare, of course, continues.